Dear viewers, this is MAHBUB TOHA. Welcome to my show, Law with MAHBUB TOHA. Today I have a distinguished guest for this program. I want to introduce him with you all. His name is Mr. Paul Turner. He's an immigration barrister. He is practicing for more than 20 years. He has been guest for this program for twice, and today we want to discuss about a very burning issue, burning law. I would say burning law, which is very important to for immigration laws, which is indefinite leave to remain, 10 years rule, after the verdict of appellate division. And another one is related with tier 2. And finally, we'll discuss about TOEIC updates, which is very known as ETS. So I would like to invite my guest today to our program, Mr. Paul Turner. Welcome to our show.
Thank you very much, MAHBUB. It's always a pleasure to be invited onto your show. And it's always a pleasure to be able to share some of my experience and hopefully advice. And I'll try to cram in as much as possible on the three topics that we're going to cover. And then at the end, I'll leave some time for people to come back. And as I say, on a personal note, I hope everyone's doing okay during the second lockdown, because I know it's very trying. I know that MAHBUB is open and they're available to help anybody, and so am I. We recognise that legal advice and help needs to continue during this time. I say this before I get going because whilst the government has talked about there being a lockdown, there's just one thing I'd like to mention at the beginning, which is that you're not supposed to go out of your house without a reasonable excuse, unless it's work, etc., or going to the doctors or seeking medical help, for example. However, one of the exceptions is to attend immigration interviews, immigration services, and that's expressly provided for in the regulations. Now, what that really means is that the Home Office are continuing to do their job. I'm continuing to get refusal letters and grants, and I'm sure MAHBUB is as well. So whilst the Home Office aren't working perhaps as quickly or as many people are working, they're still working. And I've heard stories from people that people are being detained again, and it's therefore important to have recourse to, or remember that there are people such as MAHBUB that are open if you have a problem. So don't just assume that because there's a lockdown, that means the Home Office have also gone to sleep. They haven't, and they will take and have been taking advantage, so I understand, of the lockdown to, as it were, trace people that they might not otherwise trace. That's my preliminary view. So if you do have a legal problem, you can't sweep it under the carpet until next year because of the pandemic. It needs to be addressed. Now, with that, the three subjects, as was mentioned, are going to be ILR and long residence and the recent changes in case law, Tier 2 and the Supreme Court decision, which really upsets the apple cart, and then lastly, ETS and TOEIC and where we are. And I'll save the last few minutes for anything that MAHBUB thinks I've missed or any questions that come through. Now, starting with the ILR and long residence. Now, I've seen lots and lots of people who've come to the United Kingdom and perfectly lawfully, and they've been students, they switched into PSW, post-study work, and it's important to remember that the new graduate route is reopening next year in the middle of June for people that are studying here at a degree level. PSW, then perhaps they've spent some time as a student again, or they've become a Tier 1 migrant, and then they apply for indefinite leave to remain. Perhaps in between those applications, there were certain problems and there were small gaps in your leave. Now, the immigration rules themselves, as I read them, meant that as long as the gaps were under 28 days before 28th of November 2016, or 14 days afterwards, the Home Office would overlook them. And then, so that person would qualify for indefinite leave to remain. Then there were the other types of cases where, say, an individual, I'll use the tier 2 example because it will become relevant when I talk about tier 2. Suppose a person comes, as I say, as a visitor, then a student, then PSW, then they get a tier 2 sponsor, and then the tier 2 sponsor loses its license in 2015 or 2016. So they've got 7 years and sometimes 8 years lawful residence, and then they've got their family here, they've got children under 7 born to them in the United Kingdom, and then they make an application within the 28 days or 14 days, and then the Home Office sits on it, then refuses it, and then gives the person a right of appeal. People have argued that making an application within that 28-day or 14-day period means that they should be given or treated as if they were here lawfully. Now,
well, I want to interrupt you for a second. One of our viewers requested to increase the volume. So, is it possible to?
I'll talk a bit louder.
Thank you.
Not a problem. I'm used to it. So sorry about that. I'll speak louder. So it's really no problem. I'm sorry. So at that point, there are a lot of cases in the first tier tribunal where people had either gaps in their leave, but they had leave when they applied for 10 years, or their leave had ended, but they'd made an application within the permitted 28 days or 14 days. Then some judges were allowing appeals and some judges were refusing the appeals. And so the matter went to the upper tribunal. And in the first case, Junaid Ahmed, they said that if the person made an application and they made the application after their leave had expired, then that meant that their leave didn't really continue, and therefore they couldn't rely on paragraph 276b. Then the matter went, there was another case called, funnily enough, MAHBUB Ahmed, and that went to the Court of Appeal. And in the Court of Appeal, there was a particularly harsh Court of Appeal decision, which essentially said, if even though the Home Office's own guidance says that individuals that actually have leave, so they actually do have leave at the time of the application, any gap meant that they would lose. Now that was a very strange decision. It was a very harsh decision, and the judge was very critical, the leading judge. Now, so then the matter rested. And then a lot of people felt very unhappy about this because of the unfairness. And then the case came before the Court of Appeal in a case reported as Hoque and others. And in that case, what the court did was they distinguished between the two types of people. So they said, if you had leave at the beginning of the 10 years, and then you had leave at the end of the 10 years, then if you had little gaps, you could qualify for ILR. Now, this was directly against what was the Home Office position in MAHBUB Ahmed. And when it was a full Court of Appeal, not 2 judges as in MAHBUB Ahmed, it was 3. And when they pushed the Home Office that this was not within their own guidance, the Home Office decided that yep, they weren't going to argue that MAHBUB Ahmed was right. The judge had got it wrong, and therefore, if you have got leave, but you've got small gaps and you've been here for 10 years, then you can qualify for indefinite leave to remain. The sting in the tail is that the court said that individuals whose leave had, say, ended in 2016 when they perhaps had even 9 years and 9 months leave lawfully, that the 28-day rule or 14-day rule did not extend their leave. Now, I understand that the matter may be appealed, but there's two things. There's the legal side of it, which is that two of the judges said the rules were so badly written that it was hard for anyone to make sense of it. And one of the judges said that the provision that allowed people with gaps in their leave to get ILR shouldn't be at the bottom of paragraph 276. It should be at the top of paragraph 276. And he said that was the only sensible way of reading it. The other Court of Appeal judge, Lord Justice McComb, he said he was critical. He said that the immigration rules should basically be discarded and they should start again. And he also went as far to say that it was sad that the Home Office didn't even seem to know how to implement their own policies or their own guidance. And he used the example of them changing their stand in the case of Masoom Ahmed. Now, where does that leave, as I say, people that are listening or watching? Well, there are two types of people. There are people that have had their appeals. Sorry, before I move on, I understand that this may be appealed to the Supreme Court because it was a 2-to-1, I think, judgment, and it was quite complicated. And the reasons that they gave, the three judges in the Court of Appeal, were different to the two judges in Masoom Ahmed and different to the couple of judges in the upper tribunal. So you've probably had 5, 6, 7 judges all come to more or less the same conclusion for different reasons, which shows that the law isn't clear. So it may be that there is a Supreme Court case on it. But for today, broadly speaking, there are 3 categories. There are 4 categories of people, really. There are people that have had their applications refused, and then they've gone along to court. And at the time they made the application, they had leave, but they had gaps in their leave. And it's important to remember that the case of Masoom Ahmed was decided last year, and there were lots and lots of appeals where the Home Office were relying on this, even though they changed their mind, relying on this. And it meant that a lot of people who had leave for 10 years, had leave when they made the application, but had gaps, had their appeal dismissed. Now, those individuals, and your immigration history is very important, those individuals may well have a good fresh claim. They may well have a good fresh claim. As I say, it should be done, given the complexity. As I say, MAHBUB is excellent in this field. It should be done through a proper lawyer. And if you were refused at an appeal because of one of the Ahmed cases, it's worth getting advice, because if you had leave when you made your application, but because of some silly mistakes or the Home Office errors earlier on, you will have an excellent fresh claim. But it's important that that fresh claim is set out in detail, and the relevant gaps are identified, and that the relevant law from the case of Hoque is shown to the Secretary of State. Now, if you do that, then I would imagine that the Home Office would go back on their decision to refuse you indefinite leave to remain. And if they didn't, and you weren't given a right of appeal, you'd have a good JR. And if you went before the first tier tribunal, you would probably win. There are then the people that made the applications after their leave expired in the grace period and have had their appeals dismissed. Unfortunately, they're in a more difficult position. And for them, I would wait and see if the Supreme Court does engage with this, but also to consult your lawyer to see whether there are any other reasons why you might remain. such as your children, if you have children, whether they've reached 7, whether there are any exceptional circumstances, such as somebody is very unwell, or your child has particular needs, because you still might have a good claim. You still might be able to bring things up. And I see someone said small gap means how many months or days. Now, I can chip in with that. The rule of thumb is, and the guidance is, that it used to be gaps of 28 days or 14 days would be overlooked. But there is a discretion to overlook slightly longer gaps. And that's expressly set down in the guidance, such as if there were postal delays or if there were problems with your lawyer or the Home Office. So the guidance looks at, and in one case gives 3 examples of gaps of about 28 days, and says that all 3 can be overlooked, which is essentially having essentially 3 months gap in your leave. So that gives you an idea of the time frame. But there is this provision for exceptional circumstances and Home Office discretion. So if, for example, this would be very sad, you were suffering from an illness, or a family member was suffering from an illness, and there was a bereavement and it prevented you from doing it, then you could still qualify, but you would need to produce evidence of that. So you would need to produce, if it was illness, you would need to produce medical evidence. There might be people that have had slightly longer gaps because they've had to leave the country. In those cases, it's important to explain the reasons why and to obtain evidence to support it. And I always say this, when dealing with the Home Office, you cannot provide too much evidence. You could go to MAHBUB, you could come to me, we could write the most beautiful letter setting out the law, setting out why you should win, why the gap is exceptional. But the Home Office will be looking for hard evidence, something from a GP, something from a hospital, something relating to your lawyer. Whatever it is, they will want to see it. The second reason I say why it's always very important if you do have such a gap is that if you end up before a court, either by way of judicial review or an appeal, and you've put forward some evidence, and this in the context of a judicial review, if you've put forward evidence that indicates that you couldn't, the gap was longer than 28 days because you were in a coma, for example, and the Home Office just said, ignored the fact that you were very, very unwell, and then just refused it with one of their standard letters, then you would have an excellent, in my view, judicial review claim, because the Home Office is obliged to consider all the evidence. So, and if you were before a first-tier judge, you would have the ability of speaking to the judge and giving evidence. So I think I've talked about the gaps. I think I've talked about if the gaps are a bit longer, what you need to do to put in with it. And again, a good lawyer is a good starting point for that.
Yes. Mr. Turner, I want to take another supplementary question from Mr. Samir Zaman Siddiq. He asked another question. I just brought it on the screen. If someone has continuous living 7 years, then he apply for asylum, and now he is past 10 years, will they count 10 years continuity during asylum application? I think he is written, will these count?
Well, I think the answer to that question, and someone else has also asked that question, my understanding on that is that as long as you're in the country lawfully and you are then granted asylum, then you are in a good position to apply for indefinite leave to remain. Because it's important to remember that an application for asylum, which falls under, I think it's paragraph 334 of the immigration rules, is an application for you to be given leave as a refugee. So if you arrived in the United Kingdom and you claimed you had leave when you arrived, and then you claimed asylum, and then the Home Office spent 7 years dealing with your asylum claim, and I know most people might think that's ridiculous, but I've come across cases where the Home Office haven't made a decision for 12 years. And then I don't know why the individual didn't go to a lawyer before, but they were allowed to work, so perhaps they just got on with their life and they didn't want to travel. But I have had cases where the Home Office haven't made a decision. Now, lawfully in the country means if you've been, in some respects, if you've been granted temporary admission pursuant to an asylum claim, and whilst that's being processed, it's an application for leave as a refugee, and it's an application for essentially recognition that you're a refugee. Now, those are two separate things. You can be a refugee, and say you could be a refugee in France. That doesn't mean say you have leave in the United Kingdom. So, but generally in the United Kingdom, if you're granted leave to remain as a refugee, both things are together. There's a slight anomaly, which is because refugees are allowed to bring people into the country by way of family reunion, which is paragraph 352D of the immigration rules. And the question that came up in a separate case, which was, well, now I'm a British citizen, can I still bring over my family? And the answer was, the court said yes. They said you may no longer have leave to remain as a refugee, but you have been recognised as being a refugee. And indeed, if you went back to your country of origin because you're British, you would be putting your refugee status at risk. So if you've made the asylum claim and it's taken the Home Office 7 years to grant it, and you have some other period of leave, then I think that then, yes, if you study what's called lawfully in the United Kingdom, then on that basis, I think you would have a good case. It would be wrong for the Secretary of State to say, it took us 7 years to decide your asylum case, so you don't qualify for ILR for another 10 years under the long residence basis, or you don't qualify until you've completed 5 years as a refugee. So hopefully I've answered that question. So I'll talk a bit louder. I'm sorry about that, Mr. Adhikari. I'll talk a bit louder. If you turn your volume up, hopefully that will help. But so that's the position really in respect of the 10 years that people that have had their leave, which has already, they've already had a decision. What can they do? In short, if you've been refused and you did have leave when you made the application and you did have gaps, then that refusal on the face of it, depending on the lengths of the gaps, is unlawful, and you would have a good chance, an excellent chance of getting your status sorted out. But you will need a good lawyer, and you will need to spell out everything, because the Home Office, their training is quite minimal for caseworkers, and they're given a set of guidance and computer click down buttons, and they don't have the same sort of experience as MAHBUB has or I have in dealing with the law, and they don't understand it as well. So for you, you're in a good position. For the individual who made the application after their leave expired, there may be something for you in the Court of Appeal. If not, you may wish to speak to a lawyer to see what other sort of application you can make. Now, the two other groups of people are people that are either thinking of making an application for ILR. Well, that's the group. Now, again, if your leave has expired and there is a gap and you're thinking of making an ILR application, don't waste your money on a set LR application, because it will be refused. You probably get a right of appeal, but you will probably spend a lot of money if you try to argue that your leave is somehow extended. There have now been, as I say, 3 major cases on this, and none of them go your way. Also, whilst we're talking about lawfully in the United Kingdom, I've had a lot of clients come to me who have, they've gone to dodgy representatives who've said, well, instead of making an FLRFP application, which is going to cost you a lot of money in Home Office fees, why don't you make a Regulation 8 EEA application? Now, I'm sure MAHBUB's come across lots of people, and the solicitor says, yeah, you can make them, they're great. Have you got an uncle or an aunt or a friend or a sister that's a relative, that's a European national, anywhere in Europe? And some people say yes, and they say, get them to come and live in England. And so they move to England, and then they make the Regulation 8 application, and they say, oh, I'm dependent on my uncle. And then the Home, and this is usually after the person's been in the country 6 or 7 years. The Home Office will then, they must laugh when they see these applications, because earlier applications that you will have made will be for leave as a student, where you say you can maintain yourself, or as a tier 1, it's your business. And now all of a sudden you're saying, oh, actually, I've been dependent upon my uncle all this time. They're attractive applications for people to make, because, well, until recently, the form was very small and they were free. Now they can only cost £65, as opposed to an FLRFP application with the health surcharge, which can cost nearly £3,000. So some dodgy lawyers say, just make them and you'll get a certificate that it's been received, certificate of application, which will give you the right to work. And so some people make one, and then they make two, make three of these applications. And there was a time before the case of Saha where there was no right of appeal. And people made these applications, and then they get to 10 years and they say, now I've got 10 years leave in the UK. So if anyone says, well, you can extend your leave lawfully by making an EE application, you can't. If you've been granted residence, you've got, suppose out of your 10 years, you've got a residence permit. So you've got your residence permit for, say, 5 of those years, then yes, you will qualify for indefinite leave to remain, because you will have been in the country lawfully. So what I would say is, so if you're in the position where you're either coming up to 10 years and you don't have leave, or you've just gone over 10 years, just over it, and you don't have leave, it's not worth making a set LR application, because you will be refused. And that application, I think, costs £2,389 at the moment, which is a lot of money. And all you're going to do is get an appeal. And so you could spend, if it's an individual alone, by the time you pay your lawyer to do the application and then the appeal, you could be £5,000, £6,000, £7,000, £9,000 out of pocket, and you will not win. And then if you then perhaps you marry, or perhaps you're offered a job, you're going to have a poor immigration history. So you may have a reason to remain, such as a child or some exceptional circumstances, but you should see your lawyer. For the individual who gets to 10 years and is frightened of making an application because they have like small gaps, then the case of Hoque is great news. It's fantastic news, because it means that you can safely make the application. So if you're here for 8 years or 9 years and you've got a visa that's going to carry you over the 10 years, then don't worry about the small gaps anymore, because they will be overlooked. And I can't see the Supreme Court reversing that, because that's against sensible reasoning in the case of Hoque, and it's against the rule, and it's against the Home Office's own guidance. So I think that's covered really the 10 years aspect of it, and the case of Hoque and what it means. No problem, Mr. Siddiqui. I'm glad I could help. Now, if I then turn to the tier 2 cases, now I touched upon that in the last part of my discussion, which and there are, I've seen quite a lot of people that have had tier 2 visas, or they've made an application with a valid Tier 2 certificate of sponsorship, a COS, I'll call it, though it's an ugly word, that have made an application with a valid COS. And I had one recently where the individual had the COS and it was limited to 3 months. I'll come and discuss that further, but the usual scenario is, and this is something else that I'm going to put my hand up about. There are two types of Tier 2 application. There are those Tier 2 applications that are genuine, where there is a proper job for you. Now, as long as you meet the requirements of the immigration rules, such as the job has been advertised, or if it's on a shortage list, it's less restrictive. And even with the new PBS coming in, it's less restrictive. If the job is genuine, then you really don't have anything to fear, as long as you tick the boxes that the Home Office require. But, and I'm sure I can confirm this, I have had lots of people, and they are extremely vulnerable, and somebody has promised them that if they pay £14,000, for example, that they will be given a Tier 2 certificate of sponsorship. Some of these frauds are more complicated. So they say, well, I tell you what, if you enroll on my training program, which will cost you 6, 8, 10, 14, 15,000 pounds, there's a guaranteed job at the end of it with a certificate of sponsorship. Now, there was a huge trend in student certificates of acceptance for studies about 10 years ago, when the government cracked down. And there are a number of criminals that are, they either apply for sponsorship licenses where there isn't really a need for it, but they get the sponsor license, or individuals who are talked into applying for a sponsor license, and then they sell off the certificates of sponsorship. Now, the Home Office is probably the most, they're most efficient in shutting down this type of fraud. And so what happens is, I've had a lot of people that come to me, and they're gullible enough to pay, thinking that they're going to get a job. In the United Kingdom, you don't pay an employer for a job. I don't mean to say, I'm going to say something that it might, to an English person, seem quite strange that people have paid for a job, but it may happen elsewhere that people have to do a favour to get a job. Indeed, in my practice as a barrister, up until about 50 or 60 years ago, to become a barrister, I would have to pay another barrister, a more experienced one, to be their trainee, to follow them around for 6 months or a year before I could actually practice. So it's not that alien an idea, but in the 21st century, if somebody says, if you're looking for a visa as a Tier 2 migrant, and somebody says, if you give me £10,000, I'll give you a certificate of sponsorship, you're likely to find that the Home Office they will sit on the application, investigate the sponsor by sending them an email. If the sponsor is dodgy or a criminal, or they don't really want you, they will either say that the job's gone, or they will just ignore the Home Office, and the Home Office will revoke the license. And then obviously the individuals feel very shameful about it, and they feel that they can't go to the police because they will put themselves in trouble. And so they're in a catch-2 situation. So anyone ever tells you that you've got to pay for a certificate of sponsorship, get in touch with us, and we'll sort the situation out and see what's really going on. But coming back to the genuine person, what happened was a lot of people would make an application, a genuine application, and the Home Office would then carry out checks on the sponsors. Now, they were easy to give out the licenses, but there are very strict criteria for sponsors as there were for private schools. And I've done a number of cases in the High Court of Appeal when schools had lost a couple of photographs or they couldn't provide all the details at the relevant time, and the government revoked their license, and the court said it's outside the immigration rules, it's purely up to the Secretary of State, and the case is almost always failed. So, and that's in a school whose very livelihood depends upon students. If it's an employer and they can't be bothered, or they're not that organised, for example, and they get their licence revoked, what then happens, or has been happening, is the Secretary of State then refuses your application without a right of appeal, and you're an overstayer immediately. Now, this position was very unclear because some people did manage to get appeals, and some first-tier judges thought, well, no, surely the Home Office should give them 60 days to find another sponsor, which is what they do with Tier 4 students. But when the matter went to the higher courts, what the higher courts found was, and this is really the first tier, and indeed the Court of Appeal, they found that there was no unfairness in the Secretary of State investigating the sponsor, revoking the sponsor's license, and then ending the person's leave immediately. And of course, whilst there is a 14-day grace period, getting a job within 14 days and another Tier 2 sponsor is in reality almost impossible, virtually impossible. And so this was constantly in the High Court and the Court of Appeal. They said there's no unfairness, no unfairness. Then it went to the Supreme Court in the case of Pathan, and the Supreme Court, in a very, very long and detailed judgment, found that there was procedural unfairness in not notifying the student that their sponsor was being investigated. I mean, one of the judges, a dissenting judge, said, well, the applicant should be keep in touch with their sponsor, and they should make sure that everything's fine, and there isn't an investigation going on, because if there was, they could always vary their leave. But the other four judges didn't agree with that view. And in my view, they were right, because it's unrealistic for someone who's been offered a job to expect to cross-examine their prospective employer and phone them up every week and ask if their sponsor license is okay. That'd be like, if people were to do that to me, I'd be irritated by it. Right? I'd be saying, well, everything's fine. So what the Supreme Court found was that was both procedurally unfair with an element of substantial unfairness. Now, to take this very quickly, and they quoted a decision going back to 1723, and I think we're all familiar with the story of Adam and Eve, and the substantive unfairness was the eating of the apple, as it were. The procedural unfairness element of it was the decision to make them leave the garden. So there was that's the way of looking at it. It's like the action, whether it was like fair, and whether the procedure in which it took place was fair. And the court found that the two blurred a bit, but they found that it was unfair on Mr. Pathan to suddenly be told, you've got no right to be here, even though you had you were not party to any fraud, or fraud wasn't alleged against you. What would have been really helpful was if the Supreme Court had actually said, yes, this is almost exactly the same situation as the Tier 4 students and the case of Patel. So you should get 60 days or longer to find another sponsor or make another application. And some people have even Hello, good.
Yes, yeah.
Coming back. I hope you can still hear me. So, two judges said that everything was like that should be treated essentially like tier 4. People should be given a period of time to find another employer. Very sensible. Another two judges said, yes, it's unfair, but we don't think the Secretary of State has to give extra time. So where does that leave individuals? Well, it leaves them if you've got in the position where, or it left Mr. Patan in the position that when they quashed his decision and said it was unlawful, that his leave essentially would reappear. And if he'd been here for over 10 years, he could vary the application to indefinite leave to remain. What's going to happen to other people in that situation is unclear, because the Secretary of State is still bound to refuse the applications because you don't meet the rules if you don't have a sponsor. And the Home Office unhelpfully didn't say, we will implement a system to make it fair. But I think that if you are in that position, so you find yourself in the position of you've got an outstanding tier 2 application, and then without your knowledge, your sponsor loses its license, and then you get refused, you've got a good challenge. Now, where does that leave people? And I look at a lot of immigration histories on a weekly basis who fall into Mr. Patan's case in the past. So they've made the tier 2 application, sponsor's been revoked, and then they don't have leave. And then they make another application. Some of them get leave, and so therefore they'll be able to, say, qualify under the ILR route if they get to 10 years, as I've discussed. Some of them will meet further refusals and be in the country illegally for a number of years. Where does that leave them? Well, what I would suggest it does is it puts them in the position of the individuals in the ETS cases, which will be my next subject. Now, what happened there? What happened to an awful lot of people was in 2015, they were served with an IS 151A saying, no in-country right of appeal, you've cheated, get out of the country. Now, in the case of Arsan, the Court of Appeal said, that's just wrong, that's just not right. People do have an in-country right of appeal. And then there was a squabble about what people would get out of it. And then in the case of Khan in the Court of Appeal, what the Court of Appeal said was they came down and they said, and the Home Office made a concession that individuals should be put back into the same position they were if they can prove they didn't cheat before the initial allegation of cheating. So if the last 5 years were you've been in the country unlawfully, seeking to clear your name or making applications, and then you win an appeal in 2020, then following the case of Khan, that means that really that the 5 years of overstaying should be swept away and you should be treated as being in the country lawfully. And that's an argument that I've put before a lot of first tier tribunal judges, and I've succeeded on it because it's in the consent orders from the Court of Appeal, and it's said by the Home Office to be the correct position, and it was affirmed, I think, by Lord Justice Singh that was the right approach to take. So if you look at the cases now of tier 2 refusals, if the tier 2 refusal, say 4 years ago, was because your sponsor had its license revoked and you didn't know anything about it, then you could use the same argument through a human rights claim to argue that the earlier refusal not to warn you was unlawful. Now, the Home Office might say, well, you didn't challenge the earlier refusal, and you should have gone for a judicial review within X number of months of challenging it. In my view, I don't think that would hold water in before the first tier tribunal. And that's because of what's called a legal fiction, which is the way English law works, which is that the courts don't make law, they discover the law, they interpret the law. So what they did in Patan is they discovered that the way the Home Office were doing it was illegal. And if it was illegal for Mr. Patan in 2020, it certainly was illegal for an individual in 2015, 16, 17, or 13 or 14. So I would say that if you're looking at making as I say, an ILR application, and you're an overstayer, but the reason you're an overstayer is because of a tier 2 refusal at some stage, then the case of Patan gives you the opportunity of making a further set of representations to the Home Office. Again, you need to use a solicitor to do this. I've seen individuals, very clever people, better qualified than me, but they're not immigration lawyers, and so they don't know how to write it. And also, there's a saying that a person who represents themselves has the worst lawyer, because obviously people are emotionally involved in their own cases, and I've been in that position personally myself, so I know it to be true. You lose sight of objectivity, and so it's always best to go to a lawyer, especially if the only reason you're in trouble is because of something that happened 4 or 5 years ago that wasn't your fault. And so Patan is potentially very, very important for a great number of people who, for whatever reason, found their tier 2 sponsor had lost its license. Now, this applies to the people that have paid money for the tier 2 sponsor license and the people that didn't pay money. Because unless there's an allegation of dishonesty raised against you, which I've not seen any cases like that, to say that the person is a participant in an attempted fraud, they're usually the innocent victims because they're vulnerable. I would say that you have a very good chance of putting forward a new claim and hanging it on what they say in Patan, because there's enough quotes in that case to give you an excellent chance of essentially resurrecting or bringing back your leave. It would be very hard for a first-tier judge to say, yes, the decision that made you an overstayer was unlawful 5 years ago, so now you should go home because you've been trying to clear your name for the last 5 years, or you were innocent. So the case of Patan is, in my view, more important for people that have suffered by having tier 2 applications refused without a right of appeal, or they've had their leave curtailed without any grace period. So there's a lot of people that will probably be watching, or I hope they're watching, that this case offers you a lifeline. I don't know how it will pan out in the future, but I've seen how it's panned out with the ETS cases.
Paul, before going to the next segment, I want to take one question because this viewers is waiting for long. He asked 10 years completed after JR right now. Right now, 11 years, 3 months running. So I think he wanted to know, is there any option or is there any thing he can do?
Right. Now, I can see that it's Mr. Pananiswamy. Now, in your case, if you won the judicial review, and so you won, or the Home Office conceded the judicial review, and it was against a refusal of leave, and otherwise you had leave, then yes, you will qualify, or you should qualify for indefinite leave to remain. However, if you got to 9 years, 11 months, and then were refused, and then you've done the JR and lost the JR, judicial review will not extend your leave. So it depends upon the outcome of the judicial review. If you got to 9 years, 11 months and say they certified your case as being clearly unfounded under Section 94 of the 2002 Act, and then you've gone and you've won the JR, or the Home Office have thrown the towel in and withdrawn the decision, then yes, your leave will continue. And if you don't have any big gaps, then yes, you will qualify. But but this is something that's really relevant to people, because I get asked this all the time. I'm at 9 years. If I go for JR, I'll get to my 10 years. 10 years doesn't mean a thing unless you have leave, or unless you win a judicial review that overturns a decision that took your leave away. So there's a big market out there where people are manipulated, and they think, I've just got to get to 10 years. So I'll do a couple of EEA applications, then I'll just put in a JR, and then when I add them all up, they come to 10 years. So the answer is, if you won and you had leave before, then yes, your leave will be continuing. If you didn't have leave and you lost, then it's not going to get you over. It's not going to get you indefinite leave. I hope you won in those regards. So I think that covers the tier 2. And just to summarise it, Bhutan offers a message of hope, an opportunity to rectify an earlier historic wrong, but it will need to be done properly. And I think there are quite a lot of people that will have been refused because their tier 2 sponsor lost its license. So it's a very good decision. How you use that decision depends on you, and whether you use a proper lawyer, or whether you try to do it yourself, or you go to somebody that doesn't understand the law. So that's Bhutan. Now, turning to really what I would say is I can see there from a question there from Mr. Aliaku. Home Office withdrew allegation of ETS fraud after submission of skeleton argument in appeal. Can you explain? Well, if there was no other reason, and what you're oddly enough, I had a case management review this week in which the Home Office withdrew the allegation of ETS fraud after my submissions. Exactly the same, and you're not my client, but you're in the same position. Then what does that mean? Well, not knowing all the facts of your case, if you had leave up until the ETS allegation of fraud, and there is no other real reason for you to be refused, then you stand a good chance of winning your appeal. And recently, in cases where people were refused just because of ETS, so ETS is the main reason for the refusal, Bindman's brought a case with a colleague or another barrister, and the Home Office agreed that people should be given 2.5 years leave to remain if they win the appeal. So in your case, if you have applied for leave to remain on some other basis, and they've said you can't stay as a spouse because of the ETS issue, then I would say concentrate on the ETS issue, concentrate on the case of Khan, and you should be entitled to a grant of 2.5 years. If you came here in 2010 or before 2010, you will get 2.5 years. Or if you made a SETLR application, you'll get indefinite. You should get indefinite leave to remain. If you didn't make there's also a relevant fact, which is some people win their ETS appeal. They've made an FLRFP application which was refused because of ETS. We win the appeal, and then the Home Office gives them 2.5 years. But they've been here now, say 11.5 years, and they say, don't I qualify for ILR? Now, the Home Office's answer to that is inconsistent. In some cases, I've written to the Home Office and said, look, the person's passed their life in the UK test, their English language test, and they've now been here 11.5 years. If they pay the balance for indefinite leave to remain, will you grant them ILR? Sometimes the Home Office have said yes. Sometimes they've said no. When I've tested it in court, the Home Office have resisted it, and they've said, you only asked for limited leave. Why should you get indefinite leave? Now, the answer to that is take the limited leave of 2.5 years and then make an application for ILR immediately. And then you will get if you've got 10 or 11 years, you will get your indefinite leave as long as you've got the life in UK, English language, and there are no other reasons why not. Right, now, I can see there's a question there from Mr. Dungana, and you've really hit on what I was going to talk about now, and exactly that. The upper tribunal cases, well, where are we? Well, they're listed for hearing on the 17th of December 2020. There was some discussion about the Home Office putting cases on hold at the case management review hearing, but I don't think that's actually happened. It may have done or it may not. It may just be the Home Office are slow. And briefly outlining the arguments and the issues in the case, it's a public case, so I'll put forward the arguments that are put forward. The appellants, and I'm representing one of the appellants in the case, we're arguing that a combination of the APPG report, NAO report, and the Public Accounts Committee report, when you look at the conclusions of those reports, which is you can't rely on anything that ETS has ever said or done, and you look at the paragraphs in particular, 14 to 19 of the case of MA, which says there is no chain of evidence between the test and the information that comes back from ETS, that the Home Office haven't discharged the burden of proof that of there being a case to answer. And that was in the case of SM Kadir a long time ago, about 2016 or 17. And then it was followed up in a number of other cases, MA, Mobula, and so it's been litigated. And in MA, it was agreed that basically ETS couldn't show a chain of custody, but the Home Office, and I don't quite understand why, sneaked over the line by arguing that they had this lookup tool, and the lookup tool was fantastic and was a good piece of evidence. Whereas, in my view, the lookup tool, which anyone that's had an ETS appeal or refusal will know about, is where the Home Office basically prepare a spreadsheet which says ETS said you cheated on this day. Now, in my view, the lookup tool isn't worth anything because it's dependent entirely on material from ETS. The Home Office's position is more, it's an argument that says you can't look at some of the reports because they're covered by parliamentary privilege. Now, that's something that the court will have to decide on. What is parliamentary privilege? Now, it goes back a long way, and the idea is that you can say something in Parliament without being sued. So if I was to allege that my next door neighbour was a Nazi, and ran a concentration camp, and I put that on Twitter or my Facebook page with a photograph of him, then he could sue me, rightly so, because he's a nice gentleman, and he could sue me for defamation or libel on the basis that it's untrue. If I was an MP and I stood up in Parliament and said it, I couldn't be sued. It's called parliamentary privilege. And there are a number of cases which say that you can't use material that's covered by parliamentary privilege in cases because it would mean that public officials won't tell the truth to government, to inquiries, or to the NAO, the PAC, or the APPG, that they simply they would fear that they would be sued, so they wouldn't be open, so that Parliament wouldn't be in the position to make informed decisions, so they're protected. Now, there is case law against that we'll be relying upon to say that that's just doesn't apply in this case. It's not an individual. We're not seeking to persecute an individual or prosecute them or sue them. We're just looking at what the facts are. And so that's the first line of the government's defence. The other line is, which is that the various, in particular the APPG report, doesn't carry much weight, and it's not as detailed as the earlier court decisions. On a personal level, this matter was in the Court of Appeal, and we would have had it heard and dealt with around June of this year. But the Home Office, very much the last minute, decided to find that there were errors of law in the respective decisions, even though they'd been fighting it all the way up to the Court of Appeal. They suddenly said, yes, oh, there's an error in your client's case, and the judge didn't consider all the facts or the law properly, even though they argued it at the upper tribunal that they had and won, and then were arguing it in the Court of Appeal. So I think there's an element of tactics in having the matter sent to the upper tribunal rather than the Court of Appeal. And I can't really say more than that in respect of my professional opinion and my opinion as to why they are doing it in the upper tribunal. Perhaps they think they stand a better chance of success before the upper tribunal. What I do know is that the government, in high-profile cases, will often decide what is the best place, the best outcome, whether it's better to just give people leave quietly so they go away. I represented an Afghan interpreter who was imprisoned about a year and a half ago, who they were trying to send to Austria, and that was reported by Channel 4. And then we went to the High Court, and the Home Office let him out. And after he was let out, what then happened was the Home Office quietly gave him refugee status. But they didn't really make a fuss about letting it be known that they gave him refugee status. So in some cases, they make a decision that it's better not to fight this because it's going to give us a bad reputation. But in other cases, they will make a decision that they'll fight it because there's a point of principle that needs to be decided. Now, given the number of people that ETS and TOEIC have been affected by, if they were to give way in these appeals, then obviously word would get round, and that would pretty much be the end of the Home Office being able to establish a prima facie case. It would essentially overturn the case of SM Kadir, if not in open court, then by their very actions. So that's what I think it is there.
Yes, well, we have to finish in 2-3 minutes. So there is another question. Any news for amnesty like 15 years? So you are a campaigner for amnesty.
A long campaign for an amnesty. I was involved, well, not involved, it's probably wrong, litigated a lot of cases when we last had what looked like an amnesty, but the government said that it wasn't one, which was the legacy scheme. Back in 2006, the Secretary of State for the Home Department said that the Immigration Service, the Home Office, wasn't fit for purpose. Now, that I think it's not fit for purpose now, given the number of my videos and the number of complaints that have been made about them. And they had 500,000 cases outstanding. They probably have about the same knocking around. And so they decided to do what was called a legacy scheme to clear the books. And the requirements for the legacy scheme were very, very, very low. You had to be in the country for 6 years, no criminal convictions less than a year, and you had to have claimed asylum. And then you got ILR. And then they included failed students, failed FLR applications. And then after 2012, they started refusing people, but the early people were all like, they wanted to get rid of it. As to what they're doing now, whilst Boris Johnson has campaigned for an amnesty from anything from 6 years to 12 years, depending on when he's speaking, Priti Patel seems to be going in the opposite direction. Where I think the government are going to have a problem is that there are 1 million to 1.5 million, so people say, undocumented migrants in the United Kingdom. We're in the middle of a pandemic where track and trace means reporting. I've heard that the NHS are sharing or can share information gained by track and trace to other authorities, which isn't really going to encourage people who are undocumented to take part in this program. So I think the pandemic is also going to cause a problem. And then there's Brexit. And then there's all the EU migrants that haven't yet registered. So I think by about towards the end of next year, we're going to end up with a situation where we've got all the undocumented migrants that have been in the UK for a long time, and a whole load of EU migrants that never bothered applying on time. And it may well be that the government decides to, and they will say they're acting tough, but they may well actually implement I'd like to see them rather implement a new legacy scheme whereby individuals that with no convictions and family and been here for a certain period of time are granted leave. So I don't see it happening now because of the pandemic. I think it's important to keep talking about it so that people are aware that we've done it before. The world didn't fall over because 200,000 people were granted indefinite leave. The government accept that the overwhelming majority of undocumented people will do no harm to this country. And that's the government's own spokesman. So we're in the pandemic. There's not many people working at the Home Office. We have a Home Secretary that likes to talk tough. And we're coming up to Brexit where the government wants to appear strong. So I wouldn't expect to see anything before the end of the transition period in June 2021, when they're going to be left with the mess of Brexit and a large number of EU nationals. And personally, I think it's going to look very bad on the government if they start trying to treat EU nationals that were previously here lawfully as in the same way that they treat other undocumented migrants if they're trying to continue a good relationship with other EU countries. I think it won't look very good in the press, especially if these people have been here for a long time and they've contributed. So at the moment, no, but there are more and more people criticising the Home Office. There's more and more awareness of the fact that there are a large number of people, and we're in a pandemic. Now, the Italians granted 600,000 people who were undocumented visas after the first wave because they said these were the people doing the low-paid jobs and helping out. and it's our duty as civilized people to recognise that and reward them. Portugal treats undocumented people as residents so that they don't spread the virus because they've got to go to work and they've got to feed their families. And even Joe Biden has said that he's going to issue citizenship or sort out citizenship for 11 million people in the next 12 months. So we are standing out like a sore thumb in our approach to migration, which is let them all drown in the Channel, or don't, as long as they don't get to England, it doesn't matter. And hopefully that will change. So I think that's an overall picture, which is don't expect an announcement tomorrow, but don't be surprised if towards the end of next year that they try and resolve this issue. And the pandemic has made it far worse, because if you're an undocumented migrant, you're not going to get universal credit, and you're not going to be able to access housing. So you're going to go to work whether you feel well or not. And if I was in that situation, I might go to work if I didn't feel very well, because if I stay at home, there would be no one to support me or my family. So it's a very difficult time. So not today, perhaps not tomorrow, but at some point they're going to need to get to grips with this. And from a political point of view, if you were the government that implemented an amnesty, you would be, I would imagine, securing yourself quite a lot of votes from the individuals that benefited. So there is, as well as bashing the migrants, which is what the government seems to do, there is also potential for engaging with the migrants who basically keep this country running. So fingers crossed that something does happen.
Thank you for your great discussion. I want to ask you two questions because I have had a few questions. I just took two of them. Mr. Hassan asked, I came here as a student in October 2009. I completed bachelor's and master's in UK. I sat in TOEIC exam in 2013. In 2015, I applied as an extended family member of EU citizen. First application was refused and I appealed. Later, in 2017, I applied as a dependent of Tier 4 student, which was refused. Home Office mentioned two reasons that I have TOEIC and 3C leave discontinued because of EE application. I claimed asylum in December 2017, which was refused in 2019. I appealed and lost. I completed 10 years. What should I do now? It's a big question. I got
a very short answer for that. Make of what I would say is a human rights application. If you've done the Life in UK test and you've got an English language certificate, or you've got your master's degree, so you don't need one. So if you've done the Life in UK test, you could apply for SET-LR and put in evidence to show why you didn't cheat. If you were refused because of TOEIC, put in evidence to show why you didn't cheat. The Home Office will refuse you because that's what they'll do. And then you'll get an appeal. If you can persuade a judge that you didn't cheat, then the case of Calm says you should be put back into the position you were in 2013, because it was that allegation that has caused all your problems, and then you should get indefinite leave to remain. If you don't have the KOLL and you can't take it because you don't have an identity document, put in a HRO application through your lawyer and set out the circumstances. I mean, I've seen your immigration history, it touches upon what I talked about earlier. And I've seen lots of cases with almost exactly the same immigration history, where I've done appeals, where I've won the appeal, and where the person has got themselves a visa. And the key is to focus on, if it wasn't for the TOEIC allegation, I would have continued to have leave. And if you win, the very least you should get is 2.5 years. But as you say, it's important to make a proper application, need a proper lawyer, you need to get proper evidence, and you will need to go to an appeal. But at present, you're likely, if you've got all of that, and then you stand a very good chance of winning. And if you win, it will either be indefinite leave to remain or 2.5 years.
Second question is been asked by Ms. Akhtar. She asked, I came here as a student. My daughter joined me after 6 months. After completion of my bachelor's, I was on tier 2. In the meantime, my daughter applied on 7 years route. She got a visa and I was dependent on that. Later, I applied for ILR and granted. Now my daughter completed 10 years. Which application I shall use? MN1 or set LR? Though it's not related with you, it's related to the solicitor. But if you answer, please.
If the daughter was born in the UK,
No, no, outside UK.
But the daughter's now completed 10 years.
Yes.
Then, I mean, I would say it would be the set LR for the daughter, having completed 10 years. You could possibly look at registration of the daughter as a British national on the basis that the child should be registered as British, and that would be under Section 3(1) of the British Nationality Act. And there is a charity which is run by or the head of it, the founder of it, was Solange Ardez Simmons, and I think it's called the PRBC, which is a project for the registration of children as British citizens, and they would be a good place to start if you were to look, if you wanted to try and register your child at the age of 7. It's going to be difficult because the child is still quite young, or if the child's now 10, it might not be that difficult, but you might want to look at that as an option. But the surefire thing to do is to apply for indefinite leave to remain, because a year later your child can get a British passport anyway.
The last question, Paul. I know it's been for a long time you are talking. It's Annie Lawson. It's on screen. I think you can see it.
A picture of her and somebody else, and they look quite happy. I'm in tier 4 visa holder and was refused ILR in 2017. I've spent 9 years. What's my possibility for 10 years? Thanks. Right. I'm sorry you lost your judicial review. I don't know why you lost your tier 1 visa. If you lost your tier 1 visa on the basis, if your case fell into what was called the Balagajari type cases, so you made a tier 1 application and they refused it on the basis that your business wasn't genuine, or you'd made tax amendments, and they considered that you were refused under 3225, then you could make a fresh human rights claim based upon the fact that the earlier decision was unlawful. And if you win that, then you might be in a position to apply for indefinite leave to remain. So I don't know the nature of the tier 1 refusal. And there are lots of different categories. So it depends. If it was a tier 1 and it was a tax case, then those decisions were made unlawful. And the same principle as Khan applies. If you can get a new right of appeal and show that you didn't behave dishonestly, then, and a judge believes you, then you could apply for indefinite leave to remain on the basis that the earlier decision and the earlier judicial review were incorrectly decided. If they weren't, and it was for a different reason, then you're not going to get indefinite leave to remain, from what I've seen, if you only got 9 years leave, even if you stay here for another year. I noticed that there was somebody else in the picture. Perhaps you've got family life, perhaps there are problems or insurmountable obstacles, perhaps there are children, perhaps there were exceptional circumstances that led to the tier 1 refusal, which might get you a period of leave. But unless it was a tax case refusal, it's going to be very difficult for you to just get indefinite leave to remain. I'm sorry, that depends on a negative in that regard, but if it was a tax case refusal and you were refused JR, as so many people were, I would say that you could make a fresh application which would get a minded to refuse letter or possibly a right of appeal. And if you win that, then you could argue that the earlier refusal was wrong. And therefore, if you get to 10 years, you would qualify for ILR, or you should qualify for ILR, subject, of course, to there being the life in UK and English language.
Thank you, Paul. We are at the end of the program. We have to finish it now.
To come to an end.
Thank you very much for being here. You have done a great discussion. I firmly believe our viewers will be benefited. We will invite you another day, and we will discuss another topic. Thanks once again for being with us and for your great discussion.
Thank you very much, MAHBUB. I wish you well. Stay well to all the viewers as well. Keep safe, and I hope this pandemic goes away. Take care, and God be with you.
Yes, thank you. Thank you.